Matter of McCabe versus 511 West 232nd Street. Counsel?
Good afternoon, Your Honors. Vernon and Ginsburg by Yoram Salagi for the appellant Marion McCabe. May I respectfully reserve 3 minutes of reply time?
Yes, of course.
Such an honor and privilege to argue before this court and to witness the grand entrance of these justices into this beautiful courtroom. Thank you. Your Honor, the central legal point in this case is that 2 laws passed by the New York City Council, the Local Restorative Act of 2005 and New York City Local Law Number 35 of 2016, state that the New York City human rights law should be interpreted broadly and as maximally protective of civil rights in all circumstances. These 2 laws and the fact that the New York City human rights law was amended in 2017 to include a bar against not only discrimination on marital status, but also discrimination against partners/couples clearly means that a cooperative is barred from treating couples who live together differently than those who are married. Your Honors, this is exactly what the cooperative did in the case at bar. They violated these laws by treating our client, an unmarried couple, Marion McCabe and David Burrows, different than a married couple. Under paragraph 16 of the
Can we really say that Mrs. McCabe, or not Mrs. McCabe, your client was treated differently because as an unmarried person, she did own an apartment there, didn't she?
That's a separate apartment that she doesn't live in. Her son lives there, and they're in the process. They moved to a victim in housing court recently, and he just moved out, so she's selling the
But my
apartment.
point is, isn't it really about whether or not, whatever her relationship is to Mr. McCabe, as opposed to her status as being married or unmarried?
No, Your Honor. Your Honor, that interpretation is a very narrow interpretation of the definition of marital status under the laws. And that interpretation has now been respectfully rejected by the City Council by their passage of the 2005.
So what is the definition of marital status now?
Well, Your Honor, the definition of marital status is whether you're married or not to another person. But not only that, not only is there
It has to be something more, because if it's simply that, you lose.
Well, Your Honor, one cannot be married to oneself. One has to be married to somebody else. And that's why, that interpretation of marital status, the narrow interpretation, was rejected by the City Council in 2005 and 2016. And in fact, interestingly—
In favor of what, counsel? I mean, if we're going to make a rule that's
Sure.
consistent with your position, we should know—
Sure, it's
what
very
it is.
straightforward. Now that they've also added partnerships into the protected class of discrimination, it's very simple, Your Honor. One cannot treat married couples differently than unmarried couples.
Are they really
So in this case, Your Honor—
The addition
I'm sorry,
of the
Your Honor.
addition of partnership could cut the other way. I mean, it may cut the way you're suggesting, but one could say, look, the City Council knew that there were people who were not in domestic partnerships and they were not married, but they were still couples, and they decided to provide the protection for people who had registered partnerships, but not for other couples that hadn't. What's wrong with that interpretation?
Because the City Council, in passing this law, they never require that anyone have to register in order to be deemed in order to be protected of the partnership status. There's no requirement. And I'm sorry. Go ahead, Your Honor.
It's okay. I was just gonna ask you, and feel free to finish. But doesn't the statute define domestic partners as someone who is registered?
No, it doesn't, Your Honor, because that's
I
just—
thought in the statute it did define domestic partners as folks who are registered, as opposed to someone who is in a couple and some enduring relationship. But maybe I'm wrong about
Well,
that.
there was, in one part of the statute, there is some kind of definition of what it is to be a domestic partner when you're regarding to registration. But in the specific part of the statute which says that a protected class is partnership status, it does not say that there has to be a registration.
But I think 3240A defines domestic partners as persons who have a registered partnership, and I would think that that definition applies throughout the statute, as definitions usually do, unless a provision says otherwise.
Well, this provision doesn't specifically state, quote, domestic partners. It
No, but
states
counsel,
partnership
Counsel,
status.
it says, Section 8102 defines partnership status as the status of being in a domestic partnership as defined by subdivision 3240, which in turn defines domestic partners as persons who have registered domestic partnerships, which shall include any partnership registered in accordance with the various provisions.
Even if Your Honor was to read it that way, it
I don't see any
doesn't,
other way to read
right,
it.
well, it doesn't limit the rights of an unmarried couple to, quote, they don't have to be, it defines it as being registered, but it doesn't limit the rights of people who are not registered, but who are also in a partnership relationship. It doesn't say that if you're not registered, you're not protected under the statute.
Can I follow up?
And nevertheless, Your Honor, if I could just address one key point, even without that language, even if one just relies on the language that protects discrimination against marital status, that alone is sufficient to protect unmarried couple, that it bars discrimination against an unmarried couple versus a married
Well,
couple.
then the
So to
difference, sorry, go ahead.
Thank you. To follow up, if I can, on the scope, I believe the HRL applies to terms and conditions of employment as well as housing accommodations. Is that right?
Yes, Your
Okay.
Honor.
And so, under your theory, could an employer who is operating in New York City and covered by the HRL offer health insurance only to an employee and the employee's spouse or domestic partner, or would all of those employers be required to, under your reading, now provide coverage to couples who don't have either a marriage license or a domestic partner registration?
Your Honor, if they were in a close relationship, then they would have to, that under this reading, if they were giving it to a married couple, they would have to give it to an unmarried couple too, who were in a close relationship.
Do you think that
Yes,
would
they
come
would.
as news to the employers of New York City? Or is this happening as we speak?
No, I think that in the 21st century, I think more and more employers are recognizing that.
That wasn't my question.
Yes.
You just said it's their legal obligation under the New York City Human Rights Law to
Yes.
offer insurance coverage to all couples, regardless of whether they're married, domestic partners, or anything else, as long as they meet some definition of
Yes, if they met a
coupleness.
certain standard, because like I said, under these laws, they say that the statute protecting marital status that one cannot be discriminated based on marital status, it should be liberally construed. So if an employer disagrees with that interpretation, or respectfully, if Your Honor does or someone else, the answer would be to change the law.
Well,
But
so
under
your-
this
your-
law, and in fact, Your Honor.
Your theory that essentially we have to interpret it liberally, and it means more than just the words marital status or partnership status, and applies to close relationships, I don't see close relationships in the statutory language, so we would have to fashion a test somehow if we were to agree with you. What would that test be? I mean, you say
Your Honor,
close
it's-
relationship, I'm not sure where you get that from or how we would measure that.
It is in the statute. Your Honor, it says marital status. What is marital status? Marital status is someone being married to someone
I
else
understand.
versus a couple.
Excuse me a second.
Right.
I'm trying to ask you something different.
I'm sorry, Your
Maybe I
Honor.
wasn't clear. I say, even if you have convinced us that it is not so limited, we need to know where the boundary is, so that it's
Sure.
not somebody that I met 5 minutes ago who's entitled to all these benefits. You've
Obviously
been saying
not.
close relationship. I'd like to know how you would ask us to define that, to put some guardrails around it.
Sure. the court could easily limit it to instances such as this case where a tenant of record in a co-op, a shareholder, dies, lives with another person for many years, as was the case in this instance, leaves their shares and the proprietary lease to their partner, and that partner should be deemed allowed, should be treated, that couple, that unmarried couple,
I think
should
the
be
issue that
treated
Judge
like a
Canataro
couple.
is having is, I wouldn't see a basis to limit it to co-ops and proprietary shares. We need to have something that is a broader articulation of a rule that has some parameters around it. Advocating that it's just for shareholders and co-ops is probably not what the city council imagined.
I'm not advocating that it just be for that, Your Honor, and the courts can fashion their own remedy.
Yeah, and I'm asking what are the rules you would like us to apply?
Well, here's one definition I could propose. If someone in a will makes their partner the primary beneficiary in their will,
Or
that
their
they would
friend.
inherit everything.
Correct, their friend in the will, it didn't say my partner, it didn't say my companion, it said my friend.
Your Honor, respectfully, in the will, he left her not only his co-op shares, but everything else.
No, but
And
we're
and, Your
trying
Honor,
to come
he
up with, counsel, we're trying to come up with a definition for what's a close relationship, or what I think you were briefing, asking us to look at the equivalent of a spouse.
Right, Your Honor, that's done all the time when there's issues of rent stabilization.
You're not
whether-
giving us any parameters for how to define that term, either
Your
of
Honor,
those terms.
one parameter which I would suggest respectfully is if someone leaves everything, not just their co-op, but everything in their will to their partner, whether they call them a friend, lover, or whatnot, that person qualifies as a partner.
What about folks who don't have a will? I mean, it
we
seems
look-
to me you're talking about the relationship
Right.
in a broader way. So
Right.
what are the benchmarks?
Right, well, we could look to if someone doesn't have a will, did they leave a health proxy? Here, Ms. McCabe was Mr. Burrow's health proxy. Did they
my
take care
guess
of him
is-
when he was ill, when that person
Right.
was ill for all these years? Did they live together for a
And
long?
these-
There's all these factors a court can just list. It's done all the time with rent regulatory apartments. There's certain factors when
So are
rent-
those the factors you're recommending?
Sure, Your Honor. Those could be factors, whether there was a close and interdependent relationship. That's what they wrote in after this court ruled in Braschi.
So I'm the
that a
co-op
family member.
board, I'm the
Right.
co-op board, how do I apply that test? Does the person have to come forward and say, I had a close and here's my living will, or
Yeah, sure. You could just, like, in this case, we show them the will and said, look, this person obviously has been living there for 13 years. She lived there for 13 years with Mr. Burrows. He left her everything in the will. I mean, it's really simple, Your Honor. Who leaves their co-op shares to a regular stranger or just a quote-unquote friend? This person left her his shares and the stock for the apartment and everything else. And Your Honors, he had 3 kids, and it specifically says in the will.
So what you're
that-
arguing is you can't just look at the usage of the word friend. One should look at the facts and circumstances of each individual case and what indicia of a close, personal,
Exactly.
intimate relationship may or may not exist.
Exactly, Your Honor, and it's often pretty obvious. I mean, just from looking at this and whatever he called her in the will, we don't know why he called her friend. Some people use, modern young people, they use the term lover. Some people are embarrassed by that term, they use something else. We never know, we don't know why he used the word friend, but all actions speak louder than words, and here obviously.
What about the words, what about the words that were used in the obituaries?
Exactly, Your Honor, I'm glad
But
you.
did he use that in the will?
Excuse
Did he
me.
use that in the will?
No, because he was not involved in writing. He
No,
did
no,
not.
I know that, but those seem to be words that might not be offensive to anyone, or,
Well,
right?
Your Honor, we can't say why he used that word and why he didn't. We don't know why he used that word versus something else. I mean, unfortunately, he's not around to tell us that, but we do.
well, you didn't only rely on that anyway, correct?
Right, Your Honor. And I just want to point out that in passing the 2005 and 2016 laws, the city council in their 2016 law, they ratified this court's ruling in Albinio v. City of New York, mentioning it as one of 3 cases where a court has correctly, liberally construed the New York City Division of Human Rights. And this court in Albino stated that all provisions of the city human rights law must be construed broadly in favor of discrimination plaintiffs to the extent that such a construction is reasonably possible.
Counsel, can I ask you, I'm sorry, can I ask you a different question? In this case, for whatever reason, the co-op chose not to treat McCabe as a spouse, but they did treat her as family, which is actually consistent with Braschi, which was really about who's a family, not who's spouse.
They didn't.
So what's wrong with that? Why was that not good enough?
Well, 2 reasons. One is they say they treated her as family, but then if one looks at the application they made her fill out, they made her fill out a purchaser application, which an outsider would have to fill out. So they said they were treating her as family, but then they made her do a whole application like as if it was someone
Well,
from the
yes,
street.
because it had to be
So-
a financially responsible family member.
No, they just did not ask for finance. They made her fill out a purchase application that was not just looking at the finances. It was like an outsider was buying it.
What
So
other sorts of information were they looking for?
the entire package that any buyer coming from the street would have to fill out, they made her fill out. And also, second, Your Honor, the standard was different of a family member versus a spouse. A family member would have to be financially responsible, whereas a transfer to a spouse would require no consent in any shape, matter, and form. So in doing that, they treated a married couple differently than an unmarried couple. And lastly, I just want to point out, once again, to reemphasize that the City Council has said that the definition of marital status should be liberally construed. And even in the legislative history in 2016, the person who drafted the legislative history and helped write the law, Honorable Councilwoman Annabelle Palma, rejected this court's narrow interpretation of marital status in the Yeshiva case. She specifically noted that case in rejecting it, and she is now, coincidentally, the commissioner of the Division of Human Rights, which shows that this was her area of expertise. Thank you so much for hearing me.
Thank you.
Good afternoon, Your Honors. May it please the Court, Michelle Quinn of Gallaudet, Dreyer, and Berkey for the respondent, 511 West 232nd Owners Corp. As Your Honors have correctly noted, David Burrows, the decedent whose shares are at issue here.
So counsel, over here.
I'm sorry.
Both the city and state human rights law have been amended, the city more than once, for purposes of this particular topic. What is your interpretation under those amendments of what the board could and could not do?
So this is a matter of contract, the application of a contract term.
Yeah.
This is not the application or redefinition of what constitutes a spouse. A spouse is entitled to the automatic transfer of shares.
Right.
As counsel actually just admitted, to evaluate Ms. McCabe
Yes.
as a spouse, even though she's not legally married, which is
Yes.
defined in the code as someone, a spouse is someone who is legally married.
You mean the
That-
partnership? You mean domestic partner? Is that what you're talking about?
Actually, the term spouse is defined in the human rights law under the caregiver section.
Okay.
As someone, a caregiver legally married to another person. If, as counsel suggests, we want to expand the definition of spouse to someone who meets the Braschi standard, that's actually the family, the non-traditional family relationship, which is how the cooperative treated Ms. McCabe. She did not qualify as a spouse.
No. But you're not getting my question anyway. Look, under the provision, it treats people who are married different from everybody else. It's an automatic transfer, no consent. You agree?
Yes.
Okay. So my question to you is, given the amendments to both the city and state laws,
Yes.
which require a very liberal construction, also require included other provisions that have already been discussed about partnership status and defining as such, then what are you permitted or not permitted to do? Is your position that you can still favor spouses for an automatic transfer, even with these amendments? And if so, why is that the case?
Yes, because it is a contract term. This is the application of a
Wait,
contract.
wait,
I don't
now-
know what
now I'm-
that
Now I'm
means.
really confused. If, suppose they didn't have a contract, but they had this as a policy.
No, it's in the proprietary lease.
But
Paragraph
I'm guessing,
60.
for purposes of any kind of unlawful discrimination, whether it's employment based on, race or gender or whatever it is, I've never heard anybody say that it's insulated because it's in a contract.
What I'm saying is the application.
Is your position that if you had a contract that said white people will be treated better than blacks, that would be okay?
It's not a better or worse. It is a standard of review of the transfer of the shares. It's not a better or worse. It's
Well,
not as though-
it is beneficial to be a spouse, because
Yes.
all you have to show is the marriage license, and you get the automatic transfer. That is not the case if you are not a spouse. So of course you've got a benefit. So again, I'm asking you simply, under the amended statutes, what is it that you can lawfully do? The amended statutes require a broader interpretation. My question to you is, why is it your interpretation still fits within the mandates of the city council and the state to read these respective statutes liberally?
Because there's no definition of what marital status actually means. The city chose not to define marital status.
Okay, then
So
why not
you
take a
revert to-
very broad interpretation
then
of
you
that?
revert to a plain meaning of the term marital status. That's the construction of legislation.
Yes, but I get, okay. Marital status could mean married versus not married.
Correct, it'd be married, single, widowed, divorced.
Yes.
So in
But
this
isn't the
instance.
plaintiff here being treated differently because she is not married to Mr. Burrows?
She's being treated.
Had
as-
she been married to him, she would have gotten an automatic transfer.
If she had been legally married to him,
Yeah.
she would have been entitled to the automatic transfer of
So
shares.
why isn't it the plain language to say it is therefore her marital status, that is, that she wasn't married to Mr. Burrows, that is causing her the disability of not getting the shares automatically?
Because marital status is whether or not you are single or divorced or married or otherwise, not in relation to another person. Otherwise, then you're
It's
going to
always in
expand it.
relation to another person.
Well,
If someone were to ask, what's your marital status, your response isn't, I'm married to Mr.
Right, her
Brown.
response is unmarried.
I'm
Her
single.
response is unmarried.
Her
And
response
therefore,
is-
she doesn't get the benefit of the provision. That's,
Right,
isn't that
and-
what we're talking about?
Well, let me ask you this, that the provision in the city human rights law that concerns housing
Yes.
is different from the employment provision in that the employment provision talks about the status of an individual, of a person, but the provision relating to housing talks about discrimination against a person or group of persons. So why shouldn't we read the group of persons language to say if you're discriminating against a group of persons based on their marital status, here Mr. Burrows and Ms. McCabe, that's the reason why we should read this broadly at least, to say group of persons means just what it says.
But a group of persons, Ms. McCabe is not a protected class because of her lack of a marriage to Mr. Burrows.
Why
The
not?
group of persons isn't marriage to a specific person. The protected persons are people
The
that
group
are,
of persons, Mr. McCabe and Ms. McCabe and Mr. Burrows, they're a group of persons, yes?
they're two people.
Okay, with a group of two is my
But
math
she's-
from wherever that
she's-
algebra is, a group could be two or more.
She's alleging that she's being discriminated against because she's not.
Because
does
the
not
group
meet-
she's in doesn't have the marital status of legally married.
Correct.
Okay, why isn't that marital status against a group of persons?
Because so it's the application, both the Supreme Court and the Appellate Division found that there was no discrimination. You don't even reach the issue of marital status because they applied the threshold under which Ms. McCabe was entitled to the transfer of shares by the contract term that she's a spouse or not a spouse.
I just want a little clarity, because I'm not sure about this record. The provision itself only says spouse, correct?
The provision
It's
says
just-
it's a
It's a yes or
spouse.
no. thank you.
Yes,
Okay.
it says spouse.
So then, it does appear, however, that the board read that expansively to include domestic partners. Is that just, I just wanted to be clear.
Yes,
Okay.
in understanding that there are protections again for people who, at the time, were not permitted to marry, same-sex couples were not permitted. So when we communicated with council, we said, produce a marriage certificate or a domestic partnership agreement. And when the city amended its law to include the term partnership status, and then, as your honors recognized, defined partnership status as someone who is in a partnership, a domestic partnership agreement, it didn't say with another person or as related to another person. It didn't expand it. So by analogy, then marital status can't then also expand marital status as it relates to another person, because then you're giving greater rights to someone who's not married than to someone who's in a domestic partnership agreement to another person. It doesn't evaluate.
I'm sorry, how are you getting, how are they
So-
getting more rights? Is that what you said?
Well, because
Or
if it's
greater
just,
rights?
if I'm in a, don't
Yes.
have a domestic partnership agreement,
Yes,
actually, let me take that back. If I have a domestic partnership agreement,
yes.
which then, I take that back. I'm trying to figure out the analysis. I'm sorry.
Okay, it's
The
okay.
the domestic partnership agreement, which is what partnership status
Yes.
is covered
Yes, okay.
as discrimination.
Okay.
It does not include your partnership status as it relates to another person. But if we construe what Mr. Sluggy is saying, marital status as it relates to another person, then you're creating broader coverage, broader protections to marital status than you do to partnership status. The whole point of the amendment to the city human rights law was to include, in response to Levin, the term partnership status. The abrogation of Levin, which in Morse discussed at length, was
So why don't
because,
we read all of it broadly? Isn't that the mandate?
but then where does it end? Then you're giving caregivers and close family members, then you're undermining the
Well,
the
clearly,
Braschi standard of a close family relation.
clearly, marital status and domestic partnership is referring to an intimate relationship. It's not referring to the categories that you've pointed to.
But then how do you prove that? So that a cooperative board is going to then be required to do a subjective analysis and go behind closed doors?
I thought you did that anyway. I thought
As
you
a-
argued,
as a
I thought you
family
argued
member.
that here.
As a family member. So.
I
if
thought
there's
you
a-
argued he wasn't, that she was not in an intimate partner relationship with him. I thought you did that. I thought you found a
we
way
did-
to do that.
We gave her the benefit of the doubt based on her claim that she was in a
Right.
close relationship.
Right.
We said, okay, well, we'll evaluate her as a family member, but let's look at the
Right, you
finances.
didn't,
But we
that-
didn't.
correct, you didn't evaluate her as an intimate partner, that's correct. I don't disagree with you, that is, but you
Because we're-
did argue that she's not in an intimate partner relationship, in part because you referred to her as
Friend.
friend. So you did find a way to make an argument about that.
Because the decedent himself did not regard Ms. McCabe as his spouse or domestic partner.
Right, all I'm saying is you said you
examples.
couldn't do that. How would you do that? And all I'm asking, well, all I'm pointing out to you is that you have argued that you were able to do that.
What I'm arguing is that we were able to evaluate her as a family member, not as a spouse.
Okay.
The spouse gets automatic transfer of the shares.
Why do you say he didn't regard her as his spouse when counsel indicated he gave her everything and that there were other factors? They lived together. She left her apartment to go to his apartment. Those,
So in his will, which is his own words, which was created 4 years before his death, his will and his healthcare proxy both regard her, he describes her as a friend. It's only her
but you
words that say.
recognize just simply the usage of a particular word is not necessarily always dispositive as to what a relationship is.
But then her words can't be dispositive of what the relationship is. Her just saying, we're lifelong partners.
It is not just saying. In NYCHA housing, they look at different factors.
Right.
So
And
you can define parameters as to which relationship is close family member, or if it is an intimate relationship equivalent to that of marriage.
But then you're asking a board to do a subjective analysis and to determine and
Oh,
potentially treat
please. I mean,
shareholders differently.
I've applied to co-ops a bunch of times, and I think that's exactly what they're doing. They're doing a subjective analysis about whether they want me living there, aren't they?
When there's if it's a spouse,
No,
they
I'm
don't-
not talking about a spouse, just somebody from the outside who's applying
Right,
to
yes.
buy an apartment at co-op.
Yes.
That's a subjective analysis.
Yes. Well,
So I don't-
it's usually an analysis of their financial
Well,
abilities.
there are plenty of wealthy people who've tried to get into exclusive co-ops and have been turned away because they're a rock star or they're whatever, right? I mean, you're not arguing that's objective, that there's some checklist that every board applies and it's uniform and they produce the same result every time.
But what I'm saying is if you're trying to apply a subjective analysis of the word spouse,
Yeah.
what's the proof
No,
of
not of the
whether or
word
not you're a
spouse.
spouse?
No. It's the proof of the it's subjective proof of the closeness of a relationship. That's subjective, yes, but boards make subjective analyses all the time.
Right, so in a non-traditional family relationship under Braschi, it has to be the interdependence, financial and emotional interdependence, as evidenced by, and there are a whole legion of things that you can prove.
And the board can't do
And
that?
she didn't prove it.
No, that's a
She
different
didn't-
question. Could the board use those factors? If it were compelled by law, could it do that? Or you're saying this is not a possible exercise for a co-op board?
But there's no reason for it to, because
Not
if
my
the
question.
spouse.
Not my question. Could the members of the board of your co-op use the Braschi factors and come to a result?
it-
In general, not even in this case in particular, in general.
Well, it does do that. When there is a non-traditional
Okay.
family member status or a family
So it-
member status,
okay.
they do use
Okay.
those standards. I mean, yes. But given that there is the automatic transfer provision to a spouse, it's not necessary to do that subjective analysis. And to me, it would be a very difficult threshold to analyze.
Why would it be difficult? That's what I'm having trouble with. It sounds to me like you already engage in the inquiry about whether someone qualifies as family when that's what the nature of the relationship is, and you're looking to see whether they're a financially responsible member, right? So it seems to me the co-op board can and does engage in that analysis. Why would it be, I understand your position is you don't have to do it with respect to spouses, but why would it be hard as an administrative matter to do it with respect to more folks?
So it wouldn't necessarily be difficult. It's that then are you analyzing them as a family member versus a spouse? So where there's a spouse and you can show a marriage certificate, I get the automatic transfer. If you're saying I'm a equivalent of a spouse,
Right, but if we were to conclude, and I think this is your adversary's argument, that the city HRL requires you to make a benefit that you're going to make available to someone in a couple, not just to a spouse, but to someone who can demonstrate that they're in that type of intimate relationship, you could apply factors like you do in the Braschi family context, even if you're saying you're not obligated to under the HRL, right?
Right, but then the question becomes, in doing that evaluation, do you then have the ability to approve or not approve? If I do an evaluation and I say, well, no, that's not sufficient, then you are then going to the next category of applicants for the transfer of shares, which is a financially responsible family member. That's the evaluation. If an applicant says, I'm like a spouse, and I ask for indicia of what that relationship is, that's qualification under the family member provision, not the spouse provision.
But counsel, surely you must agree, in the same way that there's a list of factors that would indicate that someone is in a family-like relationship, you could create a list of factors to say that someone is in a marriage-like relationship. Don't you think so? To me, as a general principle, that seems not remarkable.
Right, but that's the analysis under a family member standard.
So you're
again,
saying regardless, so the only thing that could be spouse is
spouse or domestic partner.
You have to be married.
Spouse or domestic partner.
And
Language of the lease.
so, but couldn't you make up a list of factors that indicate that a relationship is like a spouse or a domestic partner?
But then you're
Which by
changing the
definition
terms.
would take it out of family.
But then you're changing the terms of the lease.
Correct, and that might be necessary because of the law. That's the point that's being pushed. Can I just ask a different question here, if I
I mean,
may?
that-
If I may, thank you. My understanding is that they lived in this unit for 13 years, or have I got the wrong number on that?
According to Ms. McCabe, she's lived in the apartment with Mr. Burrows since 2006.
Okay. So what was the board's understanding of their relationship?
Caregiver.
For the entire
Roommates. I mean,
period
I
of
don't-
time?
I don't, the board is not looking behind closed doors to determine what their relationship was. They were living together, she had an apartment next door, she went back and forth, nobody really knows. It's
So-
only according to her statements.
So if he brought someone in off the street
Which
to live
she
there, it
has-
wouldn't matter to the board? I just want to be clear.
She's.
You're saying
if
you don't
she
look
brought- if
behind
she-
closed doors?
Yes,
You literally brought in someone off the street,
Yep.
kept them in the apartment. The board is not going to look behind that, doesn't matter to them.
well, she's actually.
I'm not asking
I
about her, I'm
understand,
asking
is-
about this question.
Because the roommate law provides that a shareholder can have someone else live in the apartment with them. So they're not allowed to inquire other than the identity of the roommate. They can't pass judgment on that.
Do you inquire as to whatever the relationship is that established that they are roommates?
No, I'm not entitled to. Someone else, so I'm a shareholder, I can bring someone else to come in and live with me, and I'm allowed to do that. The only thing I need to disclose to my landlord or my co-op is the identity of my roommate and when they moved in. And that is the end of the inquiry. So again, the Supreme Court, the Appellate Division, all found that there's a rational basis for this decision. This decision was governed, protected by the business judgment rule. Counsel does not dispute the fact that Ms. McCabe was not married or a domestic partner of David Burrows.
Let me ask you this. What if the court holds in his favor to this extent and says that under the city human rights law and the state human rights law, you could not choose to treat her differently than if she had been his spouse for purposes of this provision? Right? Okay. So that means she gets the automatic transfers. But what would the board do differently the next day? Moving forward, what, if anything, would you have to do?
With respect to her?
No,
or
no,
with
no.
respect to
If
evaluation?
we held in her favor, you're kind of done with that. If indeed she can establish whatever it is we say, but let's say moving forward after that.
I'm
how
not sure
would
that I
that
followed the
af-
question. How would
Right
the
now,
board
you
act
choose
differently?
only spouses. If we were to say you cannot only benefit spouses in the way you have interpreted that, perhaps in the way we've interpreted in the past, how might that change? Would it mean, for example, as some members of the court have asked, would it mean that you'd have to apply what you had identified as the Braschi factors or these factors to other cohabiting couples who are not married or registered domestic partners?
The difficulty is going to be, yes, they would have to establish some sort of a policy, but the difficulty there is then going to be,
Yes.
so for boyfriends and girlfriends or other kinds of couples that are living together, now you're treating shareholders differently for someone who claims that they are the equivalent of a spouse versus someone who's
Counsel,
just a
can I ask
boyfriend and girlfriend.
a similar question along the same lines? If we were to hold, consistent with your adversary, that, this relationship needs to be examined for its spousal-like qualities, and here's the list, and this qualifies, could the co-op then just remove from its proprietary lease this spousal preference for non-titled individuals?
Well, to amend the proprietary lease, they would need a two-thirds,
Is
a
it possible?
supermajority. I mean, they
Could
would
you
need
just
to
say,
have-
we're going to treat everybody exactly the same? It doesn't matter if you're married, not married. If you're not a titled shareholder and someone leaves, the apartment to you in their will, you're going to have to get board approval. Is that something you could do, conceivably?
In theory, but it would be a very tall standard because it would require a supermajority of all the shareholders to vote in favor of changing the proprietary lease. You would have to change the terminology. You would have to remove that provision from the proprietary lease, because then anyone purchasing the shares would have to know how they're going to be treated for a transfer of shares upon the death of a shareholder, et cetera. So that's a contract term that you would have to know upon entering into the purchase.
What is required to gain consent?
Of the board.
Numerically,
I'm sorry?
what does it require to get consent?
the financial responsibility. It's an evaluation of what the person's.
No, numerically, how many votes?
I don't know that
Is it-
offhand, Your
I'm
Honor.
sorry, is it-
It's
let
a
me put that-
66 2/3% vote of the shares.
Okay.
So it's a supermajority. It's usually a very tall
So it's
standard.
the shareholders, not the board. That's,
Correct. The shareholders would have to vote to amend the proprietary lease. Yes.
Thank you.
Okay, thank you.
Very quickly, just to clear something up, I had suggested a minimum simple standard that whereas, like here, where the shareholder dies and clearly leaves the co-op shares in the will to their unmarried partner who lives with them, that would be a simple standard where they would have to allow the automatic transfer. And Your Honor had asked me, well, what if there's no will? Well, if there's no will, then the decedent is not leaving the shares to his partner, so that partner cannot stay there because they would not be left the shares. Second, Your Honor, I just want to point out.
Let's say the state has a rule when you pass away without a will, and let's assume in this alternate universe the state is subject to this law. The state has a law that says when you die intestate, your property default first goes to your spouse. Would that violate this provision?
Your Honor, I'm not clear on that. I'm not a surrogates court
Well, just
expert.
assume that's the law. Would that, and assume this law applies to that law. Would a statute that says if you die intestate, your property goes to your spouse, violate the human rights law?
It would violate the human rights law unless there was an exception
So
in another
surrogates
area.
would have to
And
come up with
let
a
me just say
test.
why, Your Honor, because the whole reason you have these protected classes and why it's interpreted broadly is because we shouldn't rely on stereotypes in defining spouses
So the
or
answer would be
unmarried.
yes. So in that
Yes,
case, the
because you-
surrogates court would
yeah,
apply your test.
Yes, because you could have a married couple that were not in a close relationship at all and just were married because they had a certificate versus an unmarried couple who had a close relationship like they had here for 27 years. I just want
Do
to...
we really want courts in the business of drawing those lines about whether a relationship is, I don't know what, enduring enough or close enough to qualify?
What we do want, Your Honor, is courts enforcing the discrimination laws, which should be interpreted.
But I think you
So if
said in
that's what it
response, if I
take-
can finish
Right,
my
I'm
question, in
sorry.
response to Judge Garcia's question, I think you said that your interpretation would mean that you couldn't simply use a marriage license or domestic partnership certificate. So it seems to me like that would put courts in the position of assessing relationships pretty frequently.
Well, if that's what it takes to enforce discrimination laws, then the court should do that.
How
Because the
about a
whole
limit?
purpose of it is to
I'm sorry, how
avoid
about a
relying on
limit?
stereotypes.
How about a limit that says, city law that says spouses are responsible for the medical debt of this other spouse? Now, would the city be entitled to read that to include this definition of spouse? Because otherwise you're discriminating based on marital status there.
Well, you would need to treat them equally. The other analogy is, let's say someone's giving birth and the hospital allows a husband to be present, but they don't allow an unmarried partner to be present. That would be
But that's
discrimination on the flip end. So it's the same thing, Your Honor. It does work both ways. I agree with Your Honor. And I also just want to point out that my colleague basically argued throughout her argument on behalf of the co-op for a very narrow interpretation of the marital status definition. And that has been completely rejected by the city council. So while it's a position that one's entitled to take, that is not what the law is in New York City, and if one doesn't like it, one should change the law. One
Thank you,
has to
counsel.
change
Your-
the law.
Your red light is on. Thank you.
Yeah, and the business judgment
Counsel,
rule does
your
not
red
protect
light
discrimination.
is on.
Thank you, Your Honor. Appreciate it.